Welcome back to one more session. Today in this session I am going to explain about legal remedy, one of the important element of the tort. A tort is a civil wrong for which the remedy is an action for unliquidated damages. Thus, the main remedy for a tort is an action for damages. There are other remedies also, such as specific restitution of chattel and in certain cases injunction in addition to damages. But it is an action for unliquidated damages, which is an essential characteristics of remedy for a tort. It is mainly the right to damages which brings such wrongful acts within the category of torts. There are a number of unauthorized acts for which only criminal prosecution can be instituted, but they are not a tort. To understand this, there is a maxim that ubi jus ibi remedium. There is no wrong without remedy. This maxim means that where there is a right, there is a remedy. That is to say, whenever a right is violated, the person whose right has been infringed has a remedy against the person who has violated it. The maxim is also said to mean that there is no wrong without a remedy. That is to say that whenever someone is wronged, he is given some remedy. Thus, we see that this interpretation mean one and the same thing. The principle has been established for the first time in the leading case of Ashby versus White, 1703. In this case, the plaintiff was a voter in a parliamentary elections. The defendant, who was the returning officer, wrongfully refused to accept his vote. In spite of this, the candidate had won the election. The plaintiff sued the defendant for damages. The defendant contended that the plaintiff had suffered no damage as his candidate had won the election. It was held that the defendant was liable to pay damages to plaintiff as they had violated his legal right, that is right to vote, whether he was suffered any loss or not. The action on the ground that violation of plaintiff's statutory right was an injury for which he must have a remedy and was actionable without proof of pecuniary damage. His observations will make the thing clear. The justice said, if the plaintiff has a right, he must have, as of necessity, have a means to vindicate and maintain it, and a remedy if he is injured in the exercise or enjoyment of it. And indeed, It is vain to imagine a right without a remedy, for want of right and want of remedy is reciprocal. It should, however, be noted that the maxim does not mean that there is a legal remedy for every moral or political wrong. There is no remedy for a solemn promise made without consideration. A request B to advance to him a loan of 1,000, which the farmer needed for his marriage expenses. B agrees to advance the loan but fails. A has no remedy. There is no remedy for oppressive legislation, which means that there is a right, there is a remedy. Without remedy, there is no right. There is no wrong. Similarly, there is no wrong without a remedy. This is about legal remedy under the law of torts. Thank you.